episode of Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation, and welcome to another episode of Surviving the Survivor, the podcast that promises to bring you the very best guests in all of true crime. And it is not just a tagline, it is our reality. If you find a better panel on Karen Reed than what you're about to experience, I will personally refund you all of your money, and I will give you back your time as well, because you're not going to find a better panel, not on Court TV, not on, I won't mention other names, but you're just not going to find it. So stick around as we get back into Karen Reed. For those who've been living under a turtle shell, as I like to say, for the last bunch of years, Officer John O'Keefe was found outside the home of Fairview Road on January 29th, 2022. Some people believe that Karen Reed, his girlfriend at the time, in a possible fit of rage, went in reverse and killed him, while a lot of other people believe in the so-called Canton cover-up, where law enforcement officers who were out with John O'Keefe that night somehow got into some sort of rumble, killed John O'Keefe, threw him on the front lawn to die. And all I can tell you, it has become literally just a sensationalistic case that will not stop even after a mistrial, which is what we're here to discuss today. There have been developments in this case, and we're going to go through them kind of point, counterpoint, and already Catherine in Maui. Excited to see Josh Ritter, who would not be. But leading the way here, we've got to go with the elder statesman, Judge Jay Blitzman. He is retired. He served as the first justice of the Massachusetts Middlesex County Juvenile Court Division. Prior to his 24-year judicial career, he was a public defender and was the first director of the Roxbury Youth Advocacy Project. And I know his email says Harvard on it. Judge, are you affiliated with Harvard currently?
Yes, I teach trial advocacy at Harvard. I teach a cradle to prison pipeline course at Boston College, and I teach juvenile law at Northeastern. A whole lot of teaching going on.
Judge, any plans to retire, really retire and just play golf or annoy family members?
I don't play golf, and I retired as a judge, but I am active in the areas of teaching, writing, and consulting. I consult on cases regularly, criminal justice cases, juvenile and child welfare cases, always available if somebody's looking for a trial consultant as well.
There you go. He will not retire, this guy. He loves what he does. Next up, no particular order in terms of the screen, you're looking at a barren wall behind Brother Counsel, otherwise known as Martin Radner. I told him he's got to get a Brother Counsel logo. He's going to have that next time we see him. He is a criminal defense attorney out of Detroit, Michigan. And as I said, he has a very successful YouTube channel, Brother Counsel. Follow him on there. A new guest today, Anna Kaminsky. She's the director of the Criminal Defense Clinic at New York Law School. She teaches 3 other experiential learning courses, which include advocacy of criminal cases, deposition skills, and intensive trial and advocacy skills. Bottom line is she teaches law, and she'll teach us a thing or two today. And last but not least, we've got Josh Ritter, the 2015 Outstanding Prosecutor of the Year by the Association of Deputy District Attorneys out in Los Angeles. He's now a partner in the firm Eldabe Ritter Trial Lawyers. Josh also, more importantly, hosts the podcast Courtroom Confidential. Courtroom Confidential. If it's not on your podcast list, get Courtroom Confidential on your podcast list. A very quick reminder. See, our guests are so good that it takes 3/4 of the show to get through their resumes. Going to have to start tightening that up. But we are going to be in Chicago. My mother, my kids, my wife, myself, next week, doing 2 book signings. July 18th at the Bookseller in Chicago. Please come see us. I think that's at 7:00. And then on Thursday, I have to look up the name. The COE will get you that information. But on Thursday, we will be, I think it's Tuesday the 16th and Thursday the 18th, we will be at a temple in Glencoe, Long Island. Carm will be there in the flesh answering your questions. To the judge, as they say in court, may I approach and ask you, what do you think now? It's post-mistrial, and the weekend passes, and then motions are filed that one juror contacted Alan Jackson, two contacted through intermediaries or quote-unquote informants. We're now up to a fourth juror who apparently, allegedly told Alan Jackson that they were unanimous in non-guilty verdict for the most serious and the lesser charge, but were hung up 8-4 apparently in favor of guilt for the involuntary manslaughter charge. What do you make of all this post-mistrial?
Well, what I make of this is that when the government, the Commonwealth as it's called in Massachusetts, reevaluates its position, it might well think, although it's really unusual not to go forward on the murder charge, about whether or not manslaughter might be the more realistic option. What I think is that in Massachusetts, it's really, really difficult for attorneys to contact jurors. It's disfavored. Here, however, attorneys reached out. I've read the motion for the new trial. One of the things that's problematic in asserting that a verdict was reached is the reality that a verdict was not reached. When the foreperson submitted the statement about being deadlocked after the Tui Rodriguez nitroglycerin charge was given by Judge Cannoni, the foreperson reported that the jury was starkly divided. I think we were on this show commenting on what an eloquent statement that was, how carefully crafted it was. Now, if there had been a hint in that note that the jury had reached a decision on the murder charge and then was grappling with the lesser included of manslaughter, that would have given Judge Cannoni the window or opportunity to inquire further. Well, have you reached a verdict on that count, and then to get more information? There was no indication whatsoever that, in fact, that was the case. So while these post-trial revelations are incredibly interesting and very, very provocative, the verdict slip was not filled out, nor is there any indication in the statement that a verdict had been reached. And finally, while the lawyers are asserting now that they didn't have an opportunity to make a record, given how quickly the judge then declared the mistrial, no objection was made at the time that Judge Cannoni declared a mistrial, and that might have been for tactical reasons. Now, what happens since that occurred, the landscape changes. These jurors ostensibly come forward. It's totally expected that the defense team is doing exactly what they should be doing, trying to reopen the case, perhaps encourage Judge Cannoni to inquire further of the jurors. That's opening a can of worms. It would be extraordinarily unusual. So one of the questions becomes, given the information Judge Cannoni had, and that information was informed and limited by the content of the juror statements, it's not surprising that she did what she did. So it's also not surprising that, given these post-trial revelations, that attorneys Jackson and Yannetti are trying to revisit the issue, and probably will be arguing these motions and related issues on July 22nd when the parties are back before the court.
Yeah. I'm going to go counterclockwise, so we get to the only woman on the panel before I get yelled at, and that would be you, Anna. Very simple question from Jimmy H. Shouldn't the judge have asked? From my understanding on I Am No Attorney, partial verdicts are allowed in the state of Massachusetts by law. Did the judge drop the ball? And there's an interesting Boston Globe editorial about this, essentially saying no, which I'm going to get to, but does any of the onus of what is going on here rest with Judge Beverly Cannoni for not asking just a simple question? Did you reach a unanimous verdict on any of the three charges? I don't think that question was ever asked. And that's why we're in the predicament that we're in now. And Karen Reed ostensibly would have not necessarily walked out a free woman, but she would have been free of this second-degree murder charge.
So, I mean, this is a really great question. I think it's actually pretty complicated. And I think that the onus sort of falls on everyone who was in the courtroom. And what I mean by that is the prosecutors, the defense attorneys, and the judge, right? We all have a job to do when we're in the courtroom, and we all have a job to properly preserve the record, to make sure things that are, going the way that they should be going. And so I'd be hesitant to put everything on one individual, including the judge. I think what's interesting here from what I know is that when the judge got that final note where she made the determination that she was going to declare a mistrial, it sounds like there wasn't much consultation, if any, with the attorneys. And typically what will happen is when any note comes from the jury, even a note saying we've reached a verdict, before the jury is brought out, the judge will take a couple minutes to gather everyone back in the courtroom and to read the note to the attorneys and to the defendant or defendants and say, here's what's happened and here's what my plan is, right? So if there's a verdict, my plan is I'm going to bring them in and we'll hear the verdict. Or if it's something more complicated, right, they discuss what to do. And so it is surprising to me that at least didn't happen, at least from what I understand did not happen. The other thing is, we have to be really, really careful here. And I sort of am this sort of dovetails with what the judge was just saying. The jury, their deliberations, this is sort of the holy of holies, right? This is really sacrosanct. What happens in that room is supposed to stay in that room. And so judges and attorneys alike are very hesitant to ask the jurors what's going on in the room. I mean, of course, we want to know, right? I always want to know what they're saying and what they're thinking, but we respect that place. We respect that space. And so when the jurors come out, they get the autonomy, right? They're not supposed to be put on the spot and said, okay, juror number 1, where are you? Okay, juror number 3, well, now we want to know from you, where are you? The only time that kind of what we call polling happens is when there is a verdict, and then there can be a request just to say, do you agree with the verdict as it's been read? So this is, really, really interesting. And given also that there hasn't been any allegation of any interference with the jury, I also find this interesting because usually that would be the time when we would be asking jurors about what happened, right? If we thought that there was anything that occurred that shouldn't have. But here it doesn't sound like that happened. It just sounds like maybe the jurors just didn't really understand that they could have a partial verdict. And unfortunately, that may not have been communicated to them.
Let me quickly just fire another shot over the bow. Traditional media is dead, and that's because in traditional media, you've got 7-second sound bites, and now you're hearing from 4 really smart legal minds in depth, which you will never get again, ever again on TV, but you will get in the new media landscape. So even more reason to watch people like Josh Ritter, Brother Counsel, and yours truly. Brother Counsel, from Tara Ellis. I'm going to go with Tara since it's Anna and not Anna. If they don't believe that Karen Reed hit John, but aren't certain on manslaughter, does that mean they think she's responsible because she dropped him off and he died? I mean, this is a great question. I was wondering this because allegedly, on the second count, it was 8-4 in favor of guilt. I want to get Josh Ritter was talking about this repudiation of the conspiracy theory. That's next. But what do you think was going on in the jurors' minds here with this 8-4, but unanimous on the second degree? There's kind of it's not intersecting completely in terms of logic. What do you make of it?
Yeah, well, what it says to me is that they're talking about her intent. And second-degree murder obviously is an intentional crime. Involuntary manslaughter is unintentional. It seems that everybody agreed in the jury room that it was not an intentional act. She didn't throw the car into reverse, gun it in 24 miles per hour for 60 feet, and then hit him on purpose. That seems to be the consensus of the jury. And the only reason why they were deadlocked is that they weren't sure whether she had intention or not. I guess certain jurors felt that she may have hit him unintentionally, which to me, again, following this trial from literally day one, is very confusing to me why they would feel that there's not reasonable doubt when you've got all these experts who have testified clearly that the injuries to John O'Keefe, the damage to the vehicle, are not consistent with a pedestrian versus auto accident. So that really confuses me a lot that they didn't feel, at least seems like that, where maybe some of the people that were split on the second degree felt that way, but some of the other jurors who wanted to convict on involuntary manslaughter felt that she must have hit him with the car. And when you got all those experts saying it's inconsistent and there's really nothing to counteract them, there's Trooper Paul with a course from the Massachusetts State Police about reconstruction. I mean, if that doesn't equal reasonable doubt, then what does? So that's what I understand from this verdict, that they were apparently split on the intentional part. But some people felt that the biomechanical engineers weren't good enough to get to reasonable doubt. So that's what it says to me. In terms of going back to that point, if you don't mind, Joel, just what the judge was talking about, what Professor Anna was talking about, with respect to whether they're going to actually bring this jury back. And like we've seen in the Alec Murdaugh trial, if people have been following, there was allegations of jury tampering by a court clerk. Obviously, then you're going to have to bring the jurors back. The only case that they quote, and the judge read the motion as much as well as I did, I'm sure everybody here did, the only case that they quote in the defense's moving papers is a case which involved racial motivation in the jury deliberation room, where it was split initially, and then for some racial reasons, racial motivations, they decided to vote guilty. And one of the jurors didn't feel good about that, so he contacted one of the defense attorney as they were walking out and said, "Hey, this is what was going on in the jury room." And then obviously, I mean, it's a whole more facts going on in that case, but essentially that's what it comes down to. And that's when the judge felt, okay, we have to call the jury back, and this guilty verdict is not going to stand. But to say that that's what's going on over here, to compare the two. And that's the only case that they quote in their moving papers. So if they're just relying on these affidavits, by the way, one of the requirements that I've seen, that I've done a little bit of research on, is that actually you need a juror to submit an affidavit to get this even in front of a judge to even consider this. Right now, there's only been affidavits filed by the attorneys saying either what one level of hearsay, what one of the jurors have told them, or in Yanetti's case, what an informant told an intermediary who told Yanetti. So there's been no affidavit filed by a juror, and it could be done with anonymity, just like it was done in the Alec Murdaugh case, and you can have that affidavit filed. So that wasn't done, and from my understanding of the law in Massachusetts, from a little bit of research that I've done, I know I'm talking too much, Josh, so I'll give it to you in a minute.
No, please. Believe me, I don't want to follow you, so keep going.
But from the research that I've done, you've got to have an affidavit filed by the juror, by the actual jurors who are saying these things, and they didn't do that. So that's why, I mean, I've done two videos already on this specific issue, which is why I feel their second argument that they made in their motion is much more compelling to me. The fact that the judge did not give anybody the opportunity to make a full record about what she wants to do. The fact that what Anna was talking about, that they didn't give, she just didn't even read the note to the attorneys. And Josh, you can also say, when you get a note, always the judge calls you in first, talks to the attorneys before they call the jury in, and asks you, what do you think we should do about this note? Or what do you think the answer should be? And that wasn't done in this case. The second she wrote the note, she didn't even give up any opportunity. She just right away said, I'm not going to make you do that. I'm declaring a mistrial. Go back to the jury room. I'll be in 2 minutes to see you. So you're right. They didn't make an objection, Judge. But I did see in their moving papers as well that there's some case law that they cited that says that actually the fact that they didn't make an objection does not mean that they consented to the mistrial. So, which is why this other part, which is not exciting, which no one's talking about so much, everyone's talking about the jurors and what they're saying. This other part, the fact that this peculiarity with the judge, I think that's much more of a meritorious way to go about arguing this motion, which is what I would do and if I was in their shoes. So that's a little bit what I have to say. I guess I'll stop now.
I mean, it obviously, just listening to Martin and Brother Counsel here, it gets incredibly complex from a legal perspective. Shamina Wright, this has been a cry from the people who think Karen Reed is guilty, Josh Ritter, and that is that the defense is lying, as they always do. Let me just start with that. I mean, allegedly, two of the jurors came forward. Two others were through kind of third parties, what they're calling informants, which is an interesting choice of word. Let me just ask you this. If by the way, Josh worked with Alan Jackson. He knows him personally. Alan Jackson, I don't think, would ever be stupid enough to make this up out of whole cloth, that these jurors just came and said, I mean, what would be the legal repercussions for him if this was in fact not true, Josh?
Oh, it's bar card would be on the line. There's no chance he's making.
You lose your
up.
ticket. You lose your ticket.
100%.
Ticket to paradise. Yeah.
You know, I know him personally. I know that he would never lie about something like this. But even if I didn't know him, I know that any attorney is not going to, for, by the way, some long shot chance of actually getting this to turn around the verdicts. By the way, you've heard a masterclass in people evaluating this case, and I don't think anybody's of the idea that, oh, they're absolutely entitled to some sort of acquittal here. This is a long shot at best, and I can't see any attorney taking a chance on that by making something up. Because, by the way, as was pointed out, if the court is even going to entertain going down this path, they're going to want to hear from those jurors. And if those jurors aren't willing to back up what these attorneys have put in their affidavits, big problem for them. So and lastly, an affidavit is essentially a sworn statement by an attorney. So he would essentially be perjuring himself to make this up. So I don't think there's any chance of that.
Josh, there's a statement from our mod, Frankie Figs, who does so much work behind the scenes, saying, and I'm not bringing it up because I want to get to this comment for the judge, but Frankie Figs says this is just a PR stunt, in my opinion. What is it in your opinion?
I think that they were confronted with, I think that this case is unique and that it had so much public attention. So many people were so vocal and involved. And I think the jurors maybe came out of their tiny sequestered fog and realized the impact that the case they were listening to was having. And I think they probably did take it upon themselves, at least in one juror's case, to actually reach out to the attorneys directly. It's a little bizarre to me that it's this through an intermediary with the other two jurors. But if it is true that they were having these conversations, I think at least in that one juror's case, they felt that it was important for the attorneys to know about this. And the attorneys, I think, felt they couldn't ignore it. And listen, if there's a small chance that she gets an acquittal for a second-degree murder out of this whole thing, or even if it politically motivates the Commonwealth to not pursue that on the second time around at a jury trial, which I think would be a smart move aside from all of this, then I think they think it's worth it because they're just bringing this information in front of the judge. I think too that, and something I'm curious to hear from the rest of the people on the panel on is, yes, we can place some blame at the judge and not inquiring further or getting a little more detail from them before declaring a mistrial, perhaps getting some more input from the attorneys. But this jury slip, this verdict slip that they call it, was already something that Jackson had raised some issues on, and that he felt it was confusing because it didn't give that option for individual not guilty findings on the lesser includeds. It instead had kind of a overall global not guilty, then followed by boxes to indicate guilty on the greater and lesser includeds. And his consternation over that, I think, is he thought maybe we're going to run into exactly the situation we're running into now, where can they indicate a not guilty even though they might be hung on a lesser included. And I think that's what, if these jurors are to be believed, is what they're indicating took place. They didn't know, in looking at this form, they weren't finding her, she was not guilty on everything, so they can't click that box, but they also weren't finding her guilty on other things, so they essentially felt that they had nowhere to check that was appropriate, and therefore they're hung. And the note that they sent back, I think, is the other thing that's remarkable here and makes this a little bit unique. That note was, I've never seen jurors give a note like that before. I've had many cases where they come back and they go, hey, we're kind of lost. We think we're hung. What do we do? Some of us don't feel the same way about this. Can we stop now? It's kind of, this was like just, it seemed to address the case law itself, saying we are at an unmovable impasse. We're done. You could send us back for as many times as you want. We are hung,
Right.
and never indicated that meant that they, but had come to an agreement on some things, but
Exactly.
not on others.
That's
And I think that the
exactly.
judge just said,
Exactly.
"Hey, they're hung."
Yeah, it's so crazy. Judge, to you from Cabby Stevens, just moving this along a little bit. Martin Radner just got bounced. He'll be back in a moment. But Judge, there's a question here for you from Cabby Stevens. Have you, in your previous trials, questioned the jury when numerous charges are at stake? I mean, did Beverly Cannoni, the bigger question here?
Yes.
Yeah.
So the answer is
yeah.
the answer, but before getting to whether Judge Cannoni did the right thing or wrong thing,
Okay.
the answer to Cabby's question is yes, but always if there was some indication for me to have inquired about that. Again, this relates to what was just discussed, the content of the jury note. I just want to say quickly that I agree with the professor. The norm, and also with the other guests, the norm in any trial, and I was a criminal defense attorney for 20 years. I defended clients in murder cases, as well as presided over countless numbers of serious matters. The normal process when you get a jury question of any description is to bring the attorneys in. You share the note, you give them an opportunity to take a position. You may agree or disagree. Sometimes the question is about whether evidence should be read back. Can we see something? You craft but then after allowing the attorneys to be heard and make their record, you then make your decision and you proceed accordingly. So that's an issue that may be an issue here, but it's not an issue of the magnitude that's going to occasion a new trial. So, but I want to comment about the question about the ambiguity of the verdict slip. Now, I would love to listen to this discussion and review the instructions that Judge Cannoni gave, because when I charged, when there were lesser included, I would always inform the jury that if you find that the evidence does not support beyond a reasonable doubt the charge of murder, you may then consider the lesser included offenses. So that's a way to address the ambiguity of the juror's verdict. Then the jury knows directly from the judge. And my understanding is they had a copy of I believe that Judge Cannoni gave a copy of her instructions to the jury. So if there was confusion about that, those instructions are in the jury room. That's the guide to how they should proceed if, in fact, they believe that Ms. Reed was not guilty because of lack of the mens rea element of intent to kill on the murder charge. Then they proceed to whether or not there's sufficient wanton recklessness to support the manslaughter charge, and they go down the list. The government's entitled to the highest charge they could prove beyond a reasonable doubt. I would have to look at the jury instructions to have a more informed position about that. I think that it's an interesting question about tactically what the attorneys didn't do in terms of making an objection. Maybe you don't know. I've been in that situation as a trial attorney, wondering which way the jury was going. And by the way, in terms of knowing, in fact, that 12 persons had agreed beyond a reasonable doubt that Ms. Reed was not guilty of murder in the second degree, the basis of that are the assertions of these jurors. One juror who came forward and the other three, I think, through intermediaries. It's unclear to me, and it may well be disputed by other jurors if they were ever questioned, whether or not, in fact, there was a unanimous agreement as to that charge. We don't know. That's one of the reasons why this is so hopelessly complicated. And to deconstruct and go back now is incredibly difficult. I should say, in the spirit of transparency, since one of my colleagues has indicated to us that he's worked with Attorney Jackson, I've worked with Judge Cannoni. I worked with her when we were public defenders together. We were public defenders together in the same office for a number of years. Now, I haven't as it turns out, over the courses of our career, I haven't spoken or seen Beverly in many years. I retired as a judge at the end of 2019. All I can say is her reputation as a Superior Court judge is quite good. I saw the Globe editorial that you alluded to earlier, in which the Globe applauds Judge Cannone for impounding the names of jurors to avoid any kind of harassment or intimidation. The Globe supports that. The Globe raised questions about whether or not the judge should have made further inquiry as regards having reached a decision. Again, I think what was difficult in the moment for Judge Cannone, and having shared that I know her, and also as a former judge, I wonder, how I would have reacted in the absence of any indication in that final note indicating that in spite of the nitroglycerin charge, they were still starkly divided, and they were at a impossible impasse. There was no indication in that note that they had reached a verdict as to anything. So I think then inquiring at that point without any further information might not have been appropriate. But again, this is what happens with Monday quarterbacking. I think a lot of this is speculation. I do think, as I said at the outside, that if I was the prosecutor in this case and I was evaluating my case, I would think, gee, I might have a hard time proving intent to support a murder charge before any jury of 12 people. It would be extremely unusual in this state for a prosecutor's office not to try to seek a murder conviction, knowing that they have lesser includeds that they could fall back on. But if ever there was a case to revisit that decision making, I think this is the one. And I think, by the way, as regards the ethical responsibility of the attorneys, I think for them not to have acted, to take some action, would have been irresponsible on their part. Having been given this information, they would be ethically, professionally remiss in not trying to do something on behalf of their client. And what they may end up doing is creating some leverage to resolve the case. I don't know if Ms. Reed would ever consider a plea to manslaughter. Her position at trial, the defense theory was, not that. Who knows? I mean, that we'll see what develops.
In the past, I know she was firm about not taking a plea. It's all just really confounding. Both sides, as the judge alluded to in his very opening comments, they're going to be back in court on July 22nd, which is the Monday after this Monday, to actually consider next steps, including another possible trial date. According to Supreme Court precedent, if it is not signed, sealed, and delivered, there is no verdict. So I guess the buck stops there as far as, the firmness of the law goes. But to Anna, to you, this question is interesting to me from Courtney, who's a friend of the show and always here. What about an oversight mechanism within the judicial system for these judges? She asks, isn't there a chief judge that can instruct Judge Cannone to have a hearing on this ASAP? Is there sort of a hierarchy amongst the judges here where one can, so to speak, overrule another?
Well, it's a great question. And although there is hierarchy sort of built within, the trial level courts, and then of course we have our appellate courts, judges do not get to tell other judges at the same level how to handle their cases, right? And that's really important because, one of the things I think that the judge can speak from personal experience when it comes to this, but the idea is the same way that, I get to walk into a courtroom, any of these other panelists get to walk into a courtroom as an attorney and make their decisions, right? Separate and apart from sort of, sometimes there's the, what you have to do as a prosecutor and what you're told to do. The idea is we're supposed to be able to come in and say, I'm going to make the decisions about what motions I make, what I do, what I don't do, as long as it's ethical, as long as it's legal, I'm going to make those decisions. And we want our judges to have autonomy over their cases, right? This judge has spent a lot of time on this case and knows this case inside and out. And there's always going to be one side who's happy with her decisions, and there's going to be another side who's not happy with her decisions. And what we don't want to see happening is all of a sudden starting to say, well, because I decide that I don't like how she did this, I get to go to like a judge, that's her next door neighbor. Very different from my right to go to an appellate court and say, I don't like what this judge did, right? So to the extent that there's something that this judge does or doesn't do that either side disagrees with, they have their opportunity when and if this is ripe for an appeal, which it's not right. It's not there yet. But when it is, that would be the appropriate place. It would not be the appropriate place for one of her colleagues or even the chief judge, right, or the administrative judge to say, this is how you need to handle this case.
Right. So I was the first justice. And it would have been totally inappropriate for me to opine, to direct, to suggest to one of my colleagues that I disapproved of their handling of the case. I might do that afterwards in a post-mortem as part of a judicial review, performance review. But in the moment, no, it's the trial court's call. And I think, Anna's, the professor's comments are spot on. When there is a verdict, and there has been no verdict, which goes back to the double jeopardy issue, no verdict was entered. So whatever the jurors are saying, or whatever some of the jurors are saying, that was not formally entered on the record. It's not reflected on the verdict slip or anything that was said in court.
And if I can just jump onto that, Joel.
Yeah, please do.
See, and I did a little bit of a research on this, and what was interesting to me, at least under the Massachusetts law, which I researched, is, and by the way, and I said this very clearly in my videos when I was explaining this and talking about the law, that the chances of this ever going anywhere are very, very slim, because just these things don't happen. So certainly when it comes to, all the jurors now agree that it was 12-0 on something, and this is a week after they've already left and been watching all of our channels on this, right? So the chance of that happening is going to be very, slim or none. And when it comes to double jeopardy, right, everybody understands, well, if there's a verdict, certainly. If there's an acquittal, if there's a not guilty, clicked on the jury verdict form, so then of course that's double jeopardy. But what about when you have a mistrial that was declared and it was inappropriate? And what I've seen, from a little bit of research that I've done based on the defendant's moving papers, was that there's actually a right for a person to have a specific jury hear their case. If they're happy with the sitting jury, then the judge can say, you know what, I want to take a vacation this week. Let's send the jury home. We'll pick a new jury next week. Don't worry. We'll make sure they're all fair and impartial. No, that doesn't work. If you're happy with your jury, then that's the jury that gets to decide your case. And therefore, if the judge declares a mistrial inappropriately, then double jeopardy could trigger and could attach. And that's what I've seen a little bit from their moving papers. And that's where this other area. So that's why I keep telling everybody on my channel, this idea that the jurors are going to come now and tell us what they really felt, that's going nowhere in a hurry. But this other issue, that the fact that the judge may have declared a mistrial prematurely without giving opportunity for the attorneys to give a full record. And I looked at the case law here, and the case law seems to say that there's three ways. Either if the defendant requested a mistrial, then the mistrial is appropriate. If the defendant consented to a mistrial, then that's also appropriate. The question is objecting or failing to object, does that mean that you consented? And there they've got case law citing that no, the fact that you didn't object does not automatically mean that you consented. So they did not request the mistrial, that's certain. They did not consent. Certainly they can argue that way. They did not consent to the mistrial. So then it gets to the third prong, which is called manifest necessity. If the judge feels at the time, whether the defendant is requesting or consenting, who cares? The fact is that we have a jury here that's hung. So manifest necessity requires that we declare a mistrial. So the manifest necessity prong under that, and I'm just being strict on the letter of the law. The fact that whether this, this is a nice argument and maybe strictly under the letter of the law, maybe it'll fly. I don't think it's going to fly because just knowing how the system works is probably not going to happen. But, just for the exercise here, under the law, manifest necessity, they have to do two things. If the judge wants to rely on manifest necessity, the case law, at least what's quoted in the defendant's moving papers and what I've researched, is that you need to give, number one, you have to give counsel full opportunity to be heard. And number two, the trial judge must have given careful consideration to the alternatives of a mistrial. And obviously, both of those prongs were not fulfilled in this case. So I think if you just analyze this, just based on the law, the defense has a pretty decent argument that there's double jeopardy by the fact, not by the fact that there's 12 jurors that say afterwards that it was acquitted, but the fact that the mistrial was inappropriate and it should have never been declared in the way that it was. And therefore, because Karen can demand that I wanted those jurors to decide my fate, and now the judge declared a mistrial, so that's why double jeopardy would attach. So just that's where it gets me a little bit excited, although, I mean, excited in terms of legal, scholarly type of things, but practically speaking, the judge is probably right, and the professor's probably right, and Josh probably right. It's probably not going to go anywhere, and that's just because
yeah. But I agree with you about about manifest necessity, but within certain parameters. No case could be declared a mistrial unless the judge makes a finding that manifest necessity required her to do just that. So you're raising the issue: was she precipitous, premature in doing that without giving the attorneys a full opportunity to be heard? That may be a provocative legal issue. It might be that this is an issue that the attorneys might seek interlocutory relief before the case goes forward, because they're making the argument that the case was dismissed inappropriately because manifest necessity did not occur, and in fact, double jeopardy now precludes a new trial, and there's no remedy there's no remedy other than now, before impaneling a new jury, to seek interlocutory, that's emergency appellate review, and that would be done by filing a petition with a single justice of the Massachusetts Supreme Judicial Court. Yeah. Will it have traction? It's a long shot, but it's likely that the defense team will pursue that avenue. But a lot remains to be seen about including what happens on July 22nd.
Judge, I want to get back to Josh in a second, but since you are up on the dais, as you will, are you familiar with this new lawyer, Martin Weinberg? He just came on. He's a new attorney for Karen Reed. Are you familiar with him? Boston-based.
Marty Weinberg?
Yes, sir.
Marty. If it's the Marty Weinberg I know him well.
Yeah, it is probably the same Marty Weinberg. I think
he's a really, really good attorney. I mean, he is a very highly skilled, very respected attorney. Practices a lot in federal district court in Massachusetts, and quite candidly around the country. He is. Yeah, he's the real deal.
This is the same Marty Weinberg, as I was reading about him, and you're describing.
Marty's the real deal.
Yeah. So Josh Ritter, the reason I bring that up, brother counsel is bringing up. I feel like I'm listening to a law school lecture, and it's way over my head. But even a guy like Alan Jackson, who's smart, he practices in L.A. Did they bring on this guy Marty Weinberg to help them with the intricacies of Boston law? I mean, how did they, or Massachusetts law, I should say, how do they know how to pivot here from a legal perspective? That's one question. How do they know how to? But then this comment was interesting to me too. That foreman was not confused. I assume that the two attorney jurors or alternate jurors, I don't know, were similarly unconfused. LOL. If anything, it was a temporary compromise vote as part of a deliberation. But yeah, there was obviously, these were very intelligent jurors. At least the the person who wrote this note was no slouch. It just seems like there was like a gap in the process. So that's one part of it, this gap in the process. What the hell happened? And the second thing is, how does Alan Jackson know what, I mean, this is complicated stuff. How does he know what move to make next in terms of getting the justice he so wants for his client?
Well, I think that is why he brought in Marty. I mean, Alan's a phenomenal attorney, but he's a trial attorney, and these are, kind of next level appellate issues. And as you're hearing from everybody on the panel, something that many people are just not familiar with, especially given this kind of scenario of the way this all played out with the jurors, making contact with the attorneys and then finding out there was an actual acquittal, and that may have had to do with the jury slip. And this is super, super complicated stuff that I imagine there is not a tremendous amount of case law on this. And I think rightfully so, they said, let's bring in a specialist, somebody who's going to be more versed in these kind of arguments post trial to make these arguments. But I think an interesting thing to think about in this, what we're finding out about what the jurors were thinking is that if it's, let's just assume right now that everything that we're hearing is true and that they were acquitting on second degree and they were hung on the lesser included of manslaughter. And to Martin's point earlier, that means it came down to an issue of intent. Well, the defense didn't argue intent at all. They stayed away from that completely. Their entire strategy was, she did not do this. This was a cover-up. She was framed. They didn't even get into the elements in their closing arguments. They didn't even discuss, hey, and by the way, if you feel that she didn't intend to do this, here's some lesser things to include, and we're going to argue to you why she doesn't even have the criminal intent necessary for manslaughter as well. Didn't even touch it. So it's interesting to me that perhaps part of the confusion as to where the process they needed to go through as far as acquitting first before moving on to other charges, or at least recording the idea that they've acquitted on some charges before indicating that they were hung on others, might have come from the fact that the defense, and by the way, the prosecution didn't address the elements either. Neither one of them really went into the elements of the crime. It came down to, was it her car or wasn't her car? And in the defense's perspective, it wasn't her car. Therefore, we're not even going to talk about the crime because this whole thing was a frame job and she had nothing to do with it. And the prosecution, and I realized that both of them were limited to an hour, and that may have caused them to lean down their arguments significantly. But the prosecution too didn't really walk them through that idea of intent and lesser intent required for manslaughter. So maybe the jurors themselves felt this was an all or nothing prospect, which is why they felt, we're not guilty. We only have one not guilty box here, but we are hung on one of the other charges. Therefore, we're hung.
Yeah, this is really, I got to jump in because this is really fascinating. I think you make some incredibly important points. We all of us were our trial lawyers. And, when we talk about defending somebody or prosecuting, we always talk about what is the theory of the case? What is the theme? What is the through line? And that theory or theme permeates every portion of the trial. And here, it was the all or nothing. I'm almost, it's like we don't even care about lesser includeds. We're saying she didn't do anything. It wasn't her car.
Exactly.
There may have been a conspiracy. So they were all in on that. That's really fascinating. And I'm really, really glad for you, for your, mining that fertile field, so to speak. I want to get back to the juror note, though, that led to the declaration of the mistrial. When we were on this, I was on a podcast with you a few weeks ago, right? Talking about we were then talking, that panel was talking about how carefully crafted and thoughtful the jury note was, starkly divided. It was almost, it seemed to be a clear message to the judge that no matter how many times you sent us back out, we were hopelessly deadlocked. This was an insoluble impasse, starkly divided. Again, there was no intimation whatsoever that a verdict had been reached on anything. You would have thought that, and there were two jurors on this jury. There was speculation. We speculated that perhaps this note was crafted with the intent of persuading the judge to declare a mistrial because of the hopeless nature of the impasse, which comes back to these revelations, which now come up over a week later, that in fact, four of them are alleging, and I say alleging because I don't really know what all 12 jurors actually believed, that the intent required for the murder conviction was not proven. Therefore, they were finding Miss Reed not guilty of the murder charge. So the process is really, really, interesting. Remember, when we talked about the jury note, some of the panelists said this was the most carefully and thoughtful crafted jury note we had ever seen. Maybe not.
Yeah.
Right?
Or, Judge,
Maybe
I'm
not.
thinking sometimes
No.
people who are very IQ or intellectually smart, I have a friend that went to Harvard. He has trouble tying his shoes sometimes. So maybe they just they came across incredibly intelligent, but maybe they weren't being practical or street smart. But to Anna here, here's the motion to dismiss on behalf of Karen Reed from Alan Jackson, currently pending against her on the grounds that the jury reached a unanimous decision to acquit her on those charges, and alternatively, because there was no manifest necessity, the term that Brother Counsel just used, supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Miss Reed was not guilty, and therefore a retrial on such counts would violate the double jeopardy protections of both federal and state constitutions. It's interesting language, no doubt. And then a question here, Anna, from Rock Schaefer Scissors, friend of the show. Judge Canoni's jury instruction explicitly stated that they are not to include a numerical split in any communication to the court. Doesn't that imply the jury must rely on the court to ask about a split? Again, a lot of hair is being split over this, but in reading this comment, what do you make of it? I have to be honest, at this point, I get a little lost because I don't have the legal acumen that you guys, or the acuity that you guys have. But what do you make of this comment?
So I think there might be a little confusion, and it could be on my end, but typically when the instructions say we don't want to know the split, that has to do with who's voting what way, right? So they don't want the note to come back and say, we haven't reached a decision and we're, there's 4 of us that agree and the rest of us say not guilty, right? Or there are 4 of us, whatever it is, right? We don't want them to tell the numbers. So that's sort of typically what we talk about with a split, not the idea of, oh, we found guilty on count 1, not guilty on count 2, and we can't figure out count 3. So I'm not totally sure what your, what this person is asking, but typically when we talk about the instructions, it's that we don't want to know the numbers. We don't want to know what the jurors are doing. Again, the idea is that we want them to feel really comfortable and really safe in that room and to hold on to their convictions. And when and if those convictions are changed because they're persuaded by what the evidence shows, and perhaps that's because how another juror puts it to them, that's fine. But we don't want it to be because there's the pressure that they come out and say, oh, we're 11-1 this way. And then they go back and they're like, see, everyone knows you, number 1, are the holdout. So that's something that we're always concerned with. We don't want to know those numbers. Again, I think all of this is really tricky. But I agree with some of the comments, and I really agree, with Brother Counsel and what he said about, it's just what is really interesting to me is, there is sort of some potential here with this idea of why didn't the judge discuss what she was going to do with the attorneys when she got that note? I mean, it's just what we always do wherever you are in the country. This is not like a Massachusetts thing or a New York thing or a New Jersey thing or even a state or a federal thing. This is common practice that when a note comes out from the jurors, it's discussed with the judge, the attorneys, and the defendants present there so that everyone can have their say. Judge makes the ultimate determination about what will be said or what will be done, but everyone gets an opportunity to voice their opinion to be heard. So that, and going back to the motion that you had on the screen a moment ago, I think that's really where their argument has some meat to it. And you notice that they came to a decision, not a verdict, because there is not a verdict. And I think that's, really important, right? If you see there, it says on the grounds that the jury reached a unanimous decision, right? Because they can't say verdict. There is not a verdict until those jurors come out and say, we have a verdict.
Very interesting delineation there.
Joel,
Yeah, brother.
If I can just jump in, because Anna just became my favorite professor.
Yes.
How many times do you get a professor to agree with you? But I do want to also just point out, because we were talking about the note. You know, the judge was talking about the note and this elaborate note that it was so well written. You know, and really, does it really represent what everybody was saying? Because in this affidavit that Alan Jackson just filed today, which part of it's on the screen now, but there's another one, paragraph 6. You can pull that up on the screen, but I'll read it for you. Paragraph 6 says the following: Juror D said that the jury actually discussed telling the judge that they had agreed unanimously on not guilty verdicts for count 1 and 3, but they were not sure if they were allowed to say so. And then the next paragraph goes on and says that the jury believed that they were compelled to come to a resolution on all counts before they could or should report verdicts on any of the counts. And something that I spoke about today in the video was in my video on my channel. Go check it out. But something that I mentioned today was the fact that, you know, one of my last questions that I always ask on voir dire, this is like everybody knows my last 2 questions are always the same on every verdict every jury that I voir dire. The first one is, if you can't hear the evidence, will you all raise your hand and say you can't hear something or see something? I want you to see everything that goes on in this trial. That's number 1. Number 2, I say, and this is usually my last question. My last question is, there are some times when you're in the jury room and you're just not sure what you're supposed to do, and you may not understand some of the jury instructions, and you may need some more guidance. So I'm asking you, don't decide amongst yourselves what makes sense or what do you think. I'm asking all of you, will you all agree that you'll say, you know what, we're not 100% sure, we're going to ask the judge what to do? And if you're not even sure, if you're allowed to ask the judge that we are all unanimous on one part and not the other part, send a note out saying, are we allowed to even tell you that we are unanimous on one part and not on the other part? Always. So that's one of the things that I stress. It could be that if it was done in this case, and again, we weren't there by the voir dire, it was done in this case, it could be the jury would have had the tools, or at least given the advice already by the attorneys, that if we're not 100% sure, then we're going to ask the judge what we should do in this case. So yeah, you got the note saying very clearly we're deadlocked on all charges, which people are talking about, all the charges, not just a charge. Then you have this affidavit saying by the juror, well, we even sure if we're allowed to even tell you that we're unanimous or not. So yeah, we're getting.
So brother counsel, excellent point. Which is why as I said just a little while ago, I'd love to see the judge's jury instruction regarding this very issue. When she charged, and I know she did, about lesser included offenses and the ability to render a partial verdict. Again, I'd like to see what in fact she instructed the jury. And quite honestly, I have not reviewed her jury instructions.
Yeah.
I
always thought that they had a. Go ahead.
That's not that I disagree with your observation about voir dire. I love that idea. That's a brilliant idea. But I think looking at the judge's jury instructions is really, really important. I think that's going to be part of any appellate review, interlocutory or otherwise, of this issue.
By the way, Missy Cohen in the comments says Marty Weinberg was my uncle's attorney in the 1980s. He's the guy that Roy Black goes to for case law. So this is obviously a very informed and knowledgeable attorney. This guy Marty Weinberg, who has just been added to the Karen Reed team. By the way, my wife, who has an IQ of a few hundred points higher than me, it's Alan Jackson with 1 L, Bugs, but we'll fix that after the show. I'm going to get yelled at now. Here we go. Juror D, without hesitation, said in substance, every one of us will agree and acknowledge that we found Karen Reed not guilty of counts 1, murder, and 3, leaving the scene, because that's what happened. Josh, what if he's saying this, and I'm just playing devil's advocate, here comes the hate mail, but what if he's saying this, but that's not really what the other jurors would come to in terms of a conclusion? That's a big problem, right? I mean, we're relying on juror D, and now I think it's juror A, the only other one that's actually come forward, in terms of having to believe them on their word that this is all true.
Yeah, and that becomes far more of a Juror D problem than an Alan Jackson problem, to be honest, because if Juror D is the one representing this is what the rest of us were saying and how the rest of us felt on this, and Juror D is misrepresenting that, well, then Alan's just, as long as he's correctly representing what Juror D is telling him, I don't think he runs into any problems. But again, that's why if this is going to get anywhere off of the starting line, they're going to have to actually get affidavits from those jurors if they want to even further this inquiry, but which looks like there's I still think a very slim chance of that happening, because the way and Martin, the stuff that you've been pointing out about this manifest necessity sounds fascinating to me, but the way I'm hearing you, it sounds like that would then be considered a verdict or double jeopardy attaching to everything. Meaning,
I agree. That's exactly what I said. If I was writing this motion,
meaning trial over, meaning no redo on anything. Which the given the magnitude of that, my cynical mind starts to think that there probably is going to be a way that this works out that doesn't happen. Because if you have a jury that comes back and says we can't reach a verdict, and then you found out that the Commonwealth is precluded from ever retrying that would also be a miscarriage of justice, looking at it from the other angle. One thing I'm thinking about, though, if I could make a complete...
I'm sorry, Josh. It's just also really important to point out that up to this point, as far as we know, no juror has come forward to speak to anyone publicly. So, and they do have that right. They do have that right. But back to that Boston Globe editorial, Judge Beverly Cannoni, jurors' names, and the judge can speak to this much better than I can, in the state of Massachusetts, there's supposed to be transparency. But Judge, correct me if I'm wrong, I think your old colleague, Judge Beverly Cannoni, has impounded their identities for safety reasons up to 10 days, I believe. So their names could be released soon, correct?
So there's a 2015 Massachusetts Supreme Judicial Court case decided the majority opinion written by Judge Robert Cordy, which talked about jurors' names being part of the public record. This was a case that was decided in the spirit of greater transparency as regards what sometimes is viewed by the public as a rather opaque legal process. However, notwithstanding that opinion, there are circumstances where it is foreseeable that a juror might be threatened or harassed, and in those circumstances, and there were instances in the Reed case where there was, I think, a blogger who was faces an intimidation charge, concerns about harassing the.
By the way, that blogger is in court for 2 separate hearings on multiple charges, multiple counts today.
There you go. There you go. So, the editorial applauded Judge Cannoni for impounding the names of the jurors until sort of the dust clears. That's why she gave it 10 days. They'll be back in court, and this issue will be vetted again. At the same time, as you noted and I discussed earlier, the Globe did criticize the judge for not inquiring further about the split, about the nature of what was going on in terms of any split or impasse amongst the jurors. I think, the Globe editorial was, didn't really address the legal reality that in that moment, Judge Cannoni had little reason to believe that there was a reason to inquire further. Of course, then we come back to the point that we've been discussing, that whether or not the attorneys had an opportunity to be heard and to make a record. Had that occurred, perhaps there would have been, further inquiry. But the jurors would have had an opportunity before Judge Cannoni decided to made a ruling that because of manifest necessity, she was discharging this particular jury. It would have been interesting, what the attorneys might have said. I've had conversations with now that I'm off the bench, I talk a lot with members, with prosecutors and defense attorneys about the tactics of what you do when you're faced with with a hung jury dynamic, and you don't know which way the juror is leaning. You don't know, so you're not sure whether to make an objection. You're not sure what to do. Maybe they're 11-1 for you. Maybe they're 11-1 against you. I mean, my vibe, the longer that this jury was deliberating, I just had a sense that they were having a hard time believing that the requisite intent to support the murder conviction was there, and they were probably struggling on the lesser included of manslaughter. But that's all it was a vibe. Now I know that based on these juror statements, that in fact was exactly what was going on.
And Judge, if I can just jump on that because
Brother Counsel, real quick, hold that thought for 1 second, Brother Counsel. Sure. I just want to address the beauty of being back in Karen Reed land. What crap is Joel spreading today after his great 10-2 against Karen Reed? Mary, if you actually listen, by the way, your mom has to be ashamed of you. She is, but not about anything related to Karen Reed. Trust me. But she is ashamed of me. Who wouldn't be? But Mary, what I said on the last show was there is a Boston Globe bureau chief who had sources inside the Norfolk County courthouse that said it was 10-2 in favor of guilt. It wasn't on a specific charge. He was just hearing rumors of that. And right now on that second count, they're saying it's 8-4 in favor of guilt. The other two were 12-0 unanimous for acquittal. So before you go slinging mud there, Mary Burgess, I don't know where you are or who you are, and I still love you, but it's so easy. It's so easy to criticize. Why don't you start your own show or just buzz right off? Brother, sorry, Judge, you had to hear that. Brother Counsel.
I just wanted to talk a little bit about what the judge said. And by the way, I also wanted to mention that Joel does have a book that you should all order. But
Surviving the Survivor, same name. Thank you, brother.
No problem. But I just did mention to the judge that there is no defense attorney in the world that I know that exists. That if the judge would come out and say, "Oh, I got another note from the jury says that they're hung. What should we do, defense counsel?" Well, I think we should make inquiry into what they're hung on. No, mistrial as soon as you can. Just get that mistrial in, right?
I agree.
So if she would have done this, of course, this would have never even become an issue. The only reason why it became an issue is because she didn't, and now they have an argument to make about, oh, well, we could have done A, B, C, D, and E. Even though practically speaking, they wouldn't be able to pass the polygraph saying that they would have done anything like this.
Point well taken. I second that emotion wholeheartedly. I just want to say also about what the split was, 8-4, 10-2. I shared this earlier on the other podcast I was on with you. The last case I tried, the last felony case I tried in Superior Court in Massachusetts, my inside information told me that the jury was 11-1 for conviction. Reliable source. It was a court officer who was implying that he was overhearing, forgive me for sharing this, the jury deliberations. So I was fighting like hell. No, I don't want the Tui Rodriguez charge. I don't want the charge because I thought that would push the holdover. And as I shared a few weeks ago or last week, I forget when I was on earlier, it wasn't until I was in the bar later with my client when drinks are sent over to me by jurors who were empathizing with us that it was 11-1 for acquittal. But the Tui Rodriguez charge did not result in a conviction. The holdout was a holdout. And sometimes jurors really, they zealously hold on to their deeply held beliefs. And sometimes they are immovable.
Yeah. Anna, back to you from Good Egg here with the super chat. Isn't it true that if the Tui Rodriguez, which is the Allen charge in most other states, have been read and the jury comes back deadlocked a second time, the judge has to declare a mistrial? Is this the law?
I wouldn't go so far as to say that there's a has to, because a lot of times there's a lot of wiggle room. And I think that's really what we're getting to, right? The idea is that there's only so many times that the judge is going to send them back, go back and deliberate, go back and think about this again, go, look at new evidence. Do we need to read something to you again? So it's not the issue. It really is not that the judge did something wrong. she wasn't wrong in saying, listen, I've instructed them. I've given them, the Allen charge, the dynamite charge, however you want to refer to it, right? I've given that to them, and it seems like we're done here. The issue is, even if that's where we were and everyone had agreed, and I do agree that defense counsel always looks at a mistrial as a win, right? Because there's just such risk at trial that a mistrial is a win. There was no opportunity, again, based on what it appears to be, there was no opportunity for there to be even the discussion of, okay, defense counsel, you agree we should declare a mistrial? Prosecutor, you agree we should declare a mistrial? Yes. Okay, come on in. It's a mistrial, right? That step appears to be the missing step here, which may very well work in the defense's favor.
Yeah, I think that's a great point.
Yeah. Back to this Boston Globe article, and then there's a couple more points to hit, and I'll let the esteemed panel off the hook in a little bit. This is what the court wrote about impounding the jurors' names. And again, you heard the judge talk about a Massachusetts law that is supposed to keep the jurors' names transparent. But in this court document from Judge Beverly Cannoni, she writes, the court concludes that there is a real and present risk of personal harm to the jurors and to the integrity of their service. Consequently, the court finds that good cause exists to impound the names of impaneled jurors in the trial of this case, going on to say, I think, brother counsel, that it could be up to 10 days. Just curious what your thoughts are on this, because on the one hand, you want transparency, but on the other hand, this has been one of the most heated and divisive trials out there. So you want them to be safe. They even said on the last day that they could hear the Free Karen readers chanting outside. So, they were hearing the crowds out there. I think it was a smart move. What do you think?
Yeah, well, Joel, I remember one of the questions you asked me on a previous panel that we had was, what happens if the verdict comes down guilty? What do you think is going to happen to Massachusetts? And I know that I personally, on my channel, even though I am like as objective as possible, and I feel like I just talk based on the facts and the evidence, as soon as I make a point one way, the other side is all at my throat. And when I make a point the other way, then the opposing side is at my throat. And it seems like in this, there's impossible to toe the line in this case. And if you're a juror and people are going to start pressuring you, how did you vote? How did you vote? How did you vote? And it's going to be very pressurizing for them. And if they actually blurt out how they voted, well, they can be subject to some harassment. So it's absolutely the right thing for the judge to do. And everybody hopes, especially like lawyers, like all of us, that none of the jurors should see any sort of grief from this. If they want to talk about it, let them talk about it, let them share their thoughts. But now they're going to have picketers by their houses or whatnot. That's not exactly how we're going to encourage people to not duck out of jury service. So, I think that it's an important thing to keep them, for at least 10 days. And then hopefully everyone will just control themselves.
Yeah, by the way, there was Alice Ryder Field is in the chat. Remember, Joel, they were even confused regarding the verdict form. And you'll remember, Josh, your friend Alan Jackson had a heated moment with Beverly Cannoni. That's when Judge Cannoni told Karen Reed why she's smiling or laughing. But he was upset about the way these verdict forms were prepared in terms of not having a not guilty box to check. So it goes all the way back to the verdict forms themselves. But KCL, who's a big trial watcher, very knowledgeable out of Salt Lake City, and is helping us with other trials like Shanna Gardner, the impending trial of Shanna Gardner. She writes, Josh, all of the legal opinions I've heard about this have said that Judge Cannoni needs to act on this right away. And so far, it's been crickets from her. How important is the speed factor here? Brother has to leave in 5, it says. Brother, whenever you have to roll, you just give us a little wave. But how important is it for her to make a decision and make a decisive decision quickly about this?
I don't think there's any urgency on the decision. I don't think she's under some sort of statutory timeline or something like that, but I imagine she's going to address it at the same hearing that they have set. I think it's on the 22nd to address whether or not they're setting this for a retrial. And if so, when is that going to take place? But, the way the case stands right now is a mistrial has been declared, and that that's the status of the case. So I don't think I don't think she can hold off. I don't think she can ignore it. I think she obviously has to address it, and the defense is probably going to hold her feet to the fire to make sure they get some sort of answer out of her. But I even wonder if that answer is something that they're going to act, I imagine they would act upon, in ask for some sort of appellate review, even of her ruling on this motion. And the motion itself is funny because it's not asking for something particular as much as it's saying you either have to declare that she's acquitted essentially and grant her essentially double jeopardy protection, or you have to allow us to further inquire and get that process underway. So the motion itself doesn't even really ask for some immediate action, but almost like let's further figure out how to resolve this whole thing. Can I throw a curveball in the mix that I was just thinking about as we were chatting, Joel?
100%. If you do it before Martin Radner has to leave, yes.
I'm going to do it quick because I want to hear Martin's thoughts on this too. But I'm thinking if I'm Alan Jackson and I get this phone call and the person says, we acquitted your client on count 1. However, we were 8-4 on count 2. That means to me, Alan immediately realized that no one, or at least 8 of them, did not buy the fraud argument. They don't have to stick to that the second time around.
The conspiracy.
The conspiracy argument. They can pivot completely at a retrial and not bring up any of that and completely go after intent and say there's zero evidence that she was intoxicated at that time or zero evidence that she was aware that she hit him, and not even get into all of the stuff about the cops involved and the planting of evidence and the beating of him inside of the house. And maybe, it could be a strategy the second time around, realizing now that they've got this case study and essentially did a 8-week-long mock trial of that theory, and it didn't pay off how they thought it would. They could completely pivot, and I wonder if they will the second time.
Martin, I want to get your take on that real quick, though. There's a problem there, I think, and that is that there have been bloggers and others who have, in the court of public opinion, drag this narrative all over Canton, back, forth, and across, and people believe that it was this conspiracy theory. Is that going to be a problem for them, Martin, in a retrial?
Yeah, and let me just say this before I bounce out of here, and it's been a pleasure being on the panel with all of you, and of course being on STS. But I never liked the defense of a conspiracy. I never liked that defense, and I didn't think that they showed such amazing evidence of a conspiracy. I think that there's a huge question mark on what actually happened that night, and I don't have the answer to that. And I think that if that would have been their approach to this trial, I think it would have been a lot more compelling, saying, hey, we don't know what happened. One thing we do know is that there is definitely not enough evidence beyond a reasonable doubt that Karen Reed backed up her car at 24 miles per hour and going 60 feet and hit her. So what did happen? That's not your job. As a jury, that's not your job to decide, to figure out the puzzle. That's not your job. Your job is to decide whether the evidence that the prosecution presented is beyond a reasonable doubt that Karen Reed did it. You don't have to figure out what happened. So the fact that we've spoken about this, I've spoken about this a lot of times, the fact that they kind of locked themselves into a position where now they actually have some sort of burden, or the jury may feel they have some sort of burden to prove a conspiracy, is not the greatest position you want to be in as a defense attorney. So if they're looking at this again to try it again, I think that they would think, I think it would behoove them to rethink about whether they're going to put on that type of defense. But the big problem in this case is that they've already sunken in so much into this defense, and this is what they're all talking about all day long for the past year. It's tough to just completely shift your position like that.
Before you leave, Martin, I just want to say, I agree with your point. The danger of going all in on the conspiracy theory is that you also run the risk of diluting the burden of proof from proof beyond a reasonable doubt to preponderance. Which narrative do you believe? Are you going to buy our conspiracy theory, or are you going to buy their theory? And then it's either or, and you lose the benefit of the burden that the prosecution has of proving the case beyond a reasonable doubt. Every element of the offense, you could throw out possibilities, but we don't have to solve that. The prosecution.
Yeah, and just to make one more point before I bounce off, is that if I have those experts, I'm not going to argue intent or not intent. I've got those experts, those amazing experts that testify, those biomechanical engineers. I am going with the car didn't hit him 100%. That's going to be my defense. Not that she hit him, but she didn't intend for that. If I've got those experts on my side, I'm not changing my defense. So that's probably, I mean, if I was Alan Jackson, that's what I would do. But anyway, it's been a pleasure. Thank you so much, Joel. And thanks for everybody. Nice to meet everybody. And see you later.
Brother, thanks so much. Talk to you soon. Thanks for being on. Anna, this super chat, and then a few more things I want to get to, and then I promise we'll wind it up. From Kita G or Kita G here, I'm not sure which. The judge did give the attorneys an opportunity to argue their position before she gave the Allen charge of the Tui Rodriguez in Massachusetts. So why didn't she do it with the last note? Your thoughts?
Right. I mean, that's a great question. I think the most likely answer is, and I'm always hesitant to get in the mind of a judge, but I think the most likely answer is because, you know, she discussed with them, we're going to agree. I'm going to give the Allen charge, the dynamite charge. She gave it. Then they came back out with this note that said, thanks so much, Judge. Thanks for your guidance, but we're deadlocked, right? We cannot come to a verdict. And so she thought, I'm done. This is, you know, I've done what I can do. And so I'm going to declare a mistrial. It's, you know, it's like I said, I don't like to question her decision as much as, you know, I think, like I said, way at the beginning when we first started, I actually think that the blame kind of falls on all of the responsible parties there, right? So the judge probably should have given the attorneys an opportunity to see the note, hear the note, and to make argument before she did it. But it sounds like neither defense counsel nor the prosecutor said anything, either when the note came out, when she declared the mistrial, or even after she declared the mistrial, right? It's not until we've heard about this information about these jurors supposedly coming forward that anyone has said anything about that declaration of the mistrial. So I really think, you know, we got to be careful putting it all on the judge. There are other people who have responsibilities in the courtroom. And as a lawyer, you know, as a practicing lawyer, I can tell you that I take it really seriously, my responsibility to preserve that record. And if I don't say something, that's on me. I can't look back at the judge and say the judge should have done something. I should have asked the judge.
Yeah. By the way, Judge, speaking of other responsibilities, and I don't mean to cover up, let me see. Oh, there we go. So Michael Proctor's, as we know, the lead investigator on this case, an absolute misogynist who got caught on his private cell phone, just making disgusting comments about Karen Reed, totally uncalled for. Well, he's been relieved of duty, and he's on, he's been reassigned without pay, is where we're at right now. How big a factor in this whole case is this botched investigation, do you think, Judge? Because, you know, we heard him speak in his own words.
Well, you know, it's the fact that he's been relieved of duty doesn't mean that he's no longer a witness that would have to be called by the government to trial. He still may be a witness that they have to call. They may not want to call him. You know, his involvement reminds me to a degree of what happened with Mark Furman in the O.J. Simpson trial. You know, jurors don't like it when police are dishonest or they upset jurors about issues. And apparently, as Officer Proctor may well have, and that may have had an effect in the verdict or the inability to reach a verdict. So that's speculative. Sometimes police misconduct is, while it's really, really concerning, it doesn't necessarily involve evidence tampering. It may be collateral, but it might not be in the minds of the jurors. You know, jurors like to believe, this is a standard voir dire question, right? You tend to believe the word of a police officer more than you would of an ordinary citizen. That's a question you ask because you want to tease out bias, because most people are predisposed. Well, I shouldn't say it depends on the community you live in. Let's say people in certain communities are predisposed to give more credence to law enforcement. When law enforcement doesn't meet that expectation, the prosecution gets punished and might get punished very, 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 very severely. I just want to say, you know, as regards to the issue about the Allen or the Tui Rodriguez issue, in Massachusetts, and I know this is the case in every state, we're encouraged not to give that nitroglycerin or dynamite charge until we absolutely have to, because it tends to push the minority, the holdouts, towards the majority. So it's rarely, you try to avoid giving it. You give it only after you've given a fair opportunity for the jury to deliberate. When they've come back 2 or maybe 3 times saying they're stuck, they're deadlocked, you give them that charge, and it's very frequently the process. If they come back after that saying they're hopelessly deadlocked, most judges are not going to send them out again. There's no rule, as the professor said, regarding that. Judges have discretion, but it's more likely than not that having read that note, the second that Judge Cannoni is reading that note, she figures, okay, no mas. It's over. I'm going to declare a mistrial, and then we've had interesting conversation about other things that could have happened, but probably the attorneys knew that too.
Yeah. Josh, here's another, I guess, unsavory character in all this, Kevin Albert, and then we'll just put a bow on it with final thoughts. The Canton Select Board Chairman, which is basically like the town council, they met, I think it was on Monday, and Chief Rafferty has now placed Kevin Albert on paid administrative leave while an outside independent investigation is being conducted relative to his actions in a case he investigated with Michael Proctor approximately 2 years ago. What that case was, we actually found out during this trial. Back on June 12th, Michael Proctor testified during Karen Reed's murder trial that he and Kevin Albert were conducting, this is like raw meat for a lion, being Alan Jackson, that he and Albert were conducting a cold case investigation on Cape Cod back in July 2022. The two men ended their day with a quote-unquote few beers, and the next day, Proctor discovers Kevin Albert's badge in his vehicle. Proctor texts Albert, who responded by asking, "Did I take my gun?" and added a wince emoji. Alan Jackson obviously salivated when he read this, but I mean, this is a tiny little town, and just the ineptness, the unprofessionalism of these police officers is a sight to behold. I guess in the next go around, if there is one, Courtney says, poor Canton, this must be awful for them. I come from a town sort of like Canton, but in the next go around, is Alan Jackson just going to double down on this insanity and say, look, these Keystone cops couldn't have solved someone stealing a pack of gum from a 5 and dime store?
Oh yeah. I mean, I don't think he takes the foot off the gas at all, because even if he does decide to change the defense strategy and pivot a bit, as we've discussed, to more of a reasonable doubt sort of argument, or attacking the intent element sort of an argument, and abandons the full-fledged conspiracy and cover-up, the police are still on trial as far as the defense is concerned. The police are always on trial as far as the defense is concerned, because any missteps, poor investigation, corrupt law enforcement, what have you, they're going to highlight that, because again, that all goes to the standard of, can you believe this evidence? And even if they're not saying they planted evidence, the evidence can still be questioned if the people who are collecting it and presenting it in court have a reason to be impeached to some extent. So sure, I mean, this case isn't getting much better for the Commonwealth with all of the kind of fallout that's taken place since then. I do believe, from a bit of a cynical point of view, that a lot of this is just political cover-up by these departments, feeling like they have to do something because this became such a public affair. And so I think they're putting people on leave and in admin leave and paid and everything else so that they can say they've addressed it. But when this comes back around, if there's any way to get that in front of the jury, you can be sure Alan's going to do so.
Nora says, bothers me that we hardly hear John O'Keefe's name. Here's his photo. But everyone knows the names of the Alberts, McCabe's, Proctor, and Higgins names. Shame on you, Mass. Jimmy H here. I lived in 8 years in Canton, and this is very sad. I love D&E Pizza. That's owned by Chris Albert, my favorite, but then it was owned by Dennis and Eva, wonderful people. So the town is going to be reeling from this for a long time. Huge thanks to brother counsel, otherwise known as Martin Radner, a Detroit criminal defense attorney, and of course, Anna Kaminsky, who joined us for the first time. And I hope that she will come back, as you heard, a practicing lawyer, but also the director of the Criminal Defense Clinic at New York Law School. Anna, first question, will you come back?
I'd be happy to. This was a lot of fun.
Awesome. Question number 2, will there be a retrial?
You know, that's yet to be seen. I think that both sides really have to think about where they are. It'll be very interesting to see what happens on July 22nd, you know, if that date goes forward, which I bet it will. And so I'm not gonna bet on any horse yet. I just want to see what happens on July 22nd.
By the way, if you're, I think her name was Mary, if you hate us like Mary, please subscribe. If you are indifferent, please subscribe. And if you love us, think about subscribing, and you can like as well. And we're going to be beefing up our entire Patreon platform with the help of my mom, who's ashamed of me, Carmela Waldman, Holocaust survivor. She's going to be talking true crime just on Patreon, but also life, giving out some life advice. She is a licensed therapist, has a lot of perspective on all things, even though in my book at the very end, she reveals that even at 85, she knows nothing. So she kind of destroyed the whole theme of the book, getting sage advice from an older person. But Josh Ritter, the man always has good advice for me. He was named the 2015 Outstanding Prosecutor of the Year. He's now a partner in the firm El Dabe Ritter, but most importantly, he is the host of Courtroom Confidential, an amazing new podcast. Get it on your list. By the way, I got a lot of 1 stars on my Apple podcast. If you want to help me out, that's important to us. It was from Karen Reed, people who did not agree with me. If you want to balance it out, I would love some 5 stars on Apple Podcast. Hate to beg. I'm not really begging, but if you have some time, it would help us out a great deal.
And then head on over to Courtroom Confidential
and do this and do
stars on there as well.
And do this. Yeah, the Karen Reed trial really beat some of us up, but it's important to cover. So, Josh, your friend Alan Jackson, number 1, do you think he'll be back for round 2? We've heard that Yannetti will. There's been sort of questions about whether Alan Jackson will be back. Do you think he'll be back? Do you think there'll be a second trial? Do you think she'll ultimately be acquitted of these charges?
I think there will be a second trial. I think there's no way for either the Commonwealth or the defense to get out of this, with considering it a win without having a second trial. I will tell you, doing retrials is awful for a trial attorney. You put so much energy and emotion and lay everything on the table, and you're completely exhausted. And then to find out that you have to gear up and do it all over again is just nearly impossible to wrap your head around. Fun fact, the reason I know Alan is I was his law clerk when he prosecuted Phil Spector, which, by the way, hung the first time around, 10-2. So he had to go through that entire mess all over again till we were able to secure a conviction the second time around. So he is no friend of retrials. Neither is any other trial attorney. But I think that we will be seeing this again. And I think, I think he'll be a part of it. I don't see any reason why. He did an amazing job, and I can't imagine her wanting to change horses the second time around.
I don't want to be all LA and drop names, but the COE, my wife, Bugs, otherwise known as the COE or the Co, she worked alongside Keith Morrison as his intern during the Phil Spector trial for their Dateline episodes, as while Josh Ritter was working as a clerk for Alan Jackson. So there you go, taking notes. And the COE was probably bossing around Keith Morrison. I'm sure she was, which would have been funny to see. A man who nobody can boss around is Judge Jay Blitzman. That's because he is from Queens, New York, associate producer on the credits. Judge Blitzman from Queens. They say from Queens come kings. That is a line, Judge Jay, from a Run DMC song. I know you're a big Run DMC fan, but they say from Queens come kings, and one of those kings is Judge Jay Blitzman. I am now citing Run DMC lyrics to him. He was the first justice of the Massachusetts Middlesex County Juvenile Court Division. He was a criminal defense attorney for years. He teaches at Harvard. The man has a lot of wisdom. I'll leave it open for you, Judge Jay, your final thoughts here.
Well, I think there will be a retrial. If in fact the defense efforts to convince an appellate court that manifest necessity did not exist, the reality here is that an officer died. There's a victim. There has not been accountability. There's not been a full vetting or understanding of how that occurred. So I think it's in the public interest for there to be a retrial. What's going to happen at that retrial is fascinating as regards retrying cases that after hung juries. I totally agree with what's been said. I mean, I've been in that situation. It's like, I mean, I've heard really, really awkward analogies like putting on a wet bathing suit. I mean, nothing really captures just how difficult it is. You got to gear yourself up and go back at it. And those of us who've been involved in the criminal process as prosecutors and defense attorneys knows how exhausting and all-consuming the work is, especially when the stakes are so incredibly high. So I'm pretty sure if this appellate effort, the motion for new trial does not order to vacate the finding, the double jeopardy argument doesn't work, we'll be back. We'll know a lot more on July 22nd.
By the way, Judge Jay, my final question: have you been brainwashed into becoming a Boston Red Sox fan, or you?
It's never going to happen.
Mets.
Well, I got to confess. You know, when I grew up in Queens, if you were a Yankee fan, you were physically attacked.
Yeah.
But I came to Boston to go to law school in an era when the Yankees were quite bad. And this was in the Horace Clarke era, for those of you who are baseball historians. I find myself now a Yankee fan, you know, and I got to tell this, if my late dad knew that, he would not be happy. He was a Mets fan, you know.
My late dad used to sneak in with him, as he called it, his kid brother, who was 12 years younger, a nickel on the subway turnstile. And it was, I think he said 50 or 60 cents for bleacher tickets. And they'd go. My dad grew up in the Bronx, so they would go every day. Go Yankees. I'm a Yankees fan at heart, even though
it's hard to be a Yankee fan in Boston. I got to tell you, it's lonely.
Yeah, I'll tell you what, it's good to go to a Marlins game in Miami, because you can get front row seats for $5 because nobody goes and you're in and out. So I always wear
my Black Barons hat. You know, Black Barons. Willie Mays played for the Black Barons in the Negro Leagues. So when I always wear that Black Barons hat, you know, it's a way to really hide my New York roots. My dad was a New York Giant baseball fan. I'm old enough to have seen Willie Mays play live in the Polo Grounds.
Wow. So, that's amazing. And may he rest in peace.
It's embarrassing for me to admit that, but it's true.
Yeah, he just passed away. Another legend.
My hero.
There you go. Ben Mannion, St. Louis Cardinal fan to the day I die. So everyone, my dad said religion, baseball is like a religion to many. So on that note, love you, America. Love you, Boston, Mass. Love you. Are you in New York right now, Anna?
I am.
Love you, New York. Love you, LA.
Where are you in New
love
York?
You.
Where are you in New York?
Where New York, Anna?
In Manhattan.
In Manhattan. New York, New York. All right, everybody. Have a great night. By the way, Phil and Scott are back tomorrow, 5 p.m. Eastern. Watch Courtroom Confidential. Give them 5 stars. Watch STS. Give us 5 stars. And we'll talk to you tomorrow.